So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
Right away, this case pivots on something crucial: competency. In criminal court, if a defendant doesn't understand the proceedings or can't assist their lawyer, the case literally cannot move forward. This isn't about guilt or innocence yet. It's about whether the system can even legally proceed. Watch how quickly the judge locks into that issue.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza.
This is a massive moment. When a judge declares someone incompetent, everything pauses. No trial, no plea, no sentencing. Instead, the court shifts from punishment to treatment. And that tells you the judge is prioritizing due process over speed. Do you think courts handle mental health issues like this consistently? Or does it depend on the judge?
I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
And just like that, we transition from one defendant's mental health crisis to an entirely different case. A reminder of how courtroom dockets move fast, even when the human stakes are enormous. No pause. No reflection. The system keeps rolling.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial. I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff.
No, go on.
We're going to get you, we're going to get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay? Right there, go back, go to the back, okay? Go to the back.
Court is calling 2025 CR 006165 State versus Juliana Guzman. Can I have parties announce?
Listen closely here. Assault on a peace officer as a second-degree felony is no joke. 2 to 20 years is real prison exposure. Deferred adjudication may sound like a break, but it's actually a legal tightrope. One misstep, and that guilty finding snaps into place. Would you take that risk?
And are you Ms. Guzman?
Yes, Your Honor.
And for the state?
Lauren Espinoza for the state.
Counsel, you received all discovery. Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Ms. Guzman, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, I believe we are proceeding on counts 1 and 2.
That's correct.
Any objection to the waiver of count 3?
None, Your
Ms. Guzman, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, in count 1 and count 2, you're charged with assault of a peace officer or judge as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you ready to proceed with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, probably read on the police report, she called the police department because she was having an episode and she needed help with her infant daughter. But when the officers got there, they understood the situation.
Here's where the story gets layered. Prior warrants, a smuggling case in another county, CPS involvement, and a child already removed from the home. This isn't just a criminal case anymore. It's criminal court, family court, and rehabilitation all colliding at once. And that's where outcomes become fragile.
They handled it, in my opinion, correctly. What happened with my client is that she had 2 warrants out of another county. So the officers go, we weren't really going to do much today, but we got to take you in because of those 2 warrants. So at that point, she goes, no, I can't, because what about my baby? Who's going to take care of her? And da-da-da. So that's how all this happened. But the officers were not really going to proceed, but they were forced to because of the 2 warrants that she had from another county judge. So I already explained that to my client. I said, you have 2 warrants. They have the right to arrest her.
All right, so this case from McMullen County, what is that about?
It's a charge for smuggling a person. A person.
And she got 5 years, according to her, 5 years deferred. But she was ordered to go to some drug rehab program, and she's waiting a bit for that, judge. But they wouldn't take her if she had something pending.
Oh, no, they will not.
Yeah, so that's why we're here, judge.
And where is your child?
CPS as of right now.
Okay. All right, this is what the court will do. The court is going to run this concurrent with M210028CRB. Regular reporting by Zoom or in person. Regular random UAs, $1,000 fine that will be prorated. And probation, if you can find out if she's being, what inpatient program she's being sentenced to on that case, on the M210028CRB.
What I've been told, Judge, just simple. I think it was safe.
All right, they're thinking it's safe P. So we'll do a TAP evaluation. But if you are able to discover that it is safe P, then I will sentence her to safe P as well. Followed by continued outpatient treatment. Yes. The probation will contact you. They may not need to do another TAP evaluation if she's already been sentenced to safe P. We're just trying to discover that. There is going to be compliance with CPS. No unsupervised contact with minors. No residing in households with minors. If CPS decides that supervised contact is correct, or you can reside in the household, you need to come back here for a hearing on that. And when I do hearings on that, I require that somebody from CPS is either by Zoom or in person. 5 years deferred adjudication, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. Probation, if CPS is requiring her to do parenting classes, which they should, then that can count for this case as well. And how far did you go in school?
I graduated in some colleges.
All right. So what are your plans for your career?
Chef. I want to go to culinary school.
All right. And if she completes, if she obtains her culinary certification, the remaining community service hours will be deemed satisfied. So you can make the decision. Either you want to do that or you want to spend time in the Texas heat picking up trash. Probation is, there'll be field visits upon release until 1 time per month until further notice. Probation, is there anything else?
This warning is as serious as it gets. The judge is spelling it out. Follow the plan, communicate, do the work, or risk permanently losing parental rights. Deferred adjudication isn't mercy without conditions. It's opportunity with a countdown clock. Do you think this system sets people up to succeed or to fail?
All right, thank you. Proof of employment within 45 days of release. No employment as a home health care provider or with minors.
Understood.
Oh, didn't I say 5 years deferred?
Yes, Your Honor.
Yes, it's 5 years deferred. Probation, is there anything else?
She had said no, Judge.
Oh, she said no? All right, someone's talking to her. All right, did you review the trial court certification of anything else, probation? All right, anything else you need from the court to be successful? Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. With CPS cases, you need to stay in contact with your CPS attorney. You need to follow through on everything that they're doing. On that side, you only have a year to complete things. And they will extend you, but they have to have good cause to extend you. So I'm sure that because you're going into inpatient treatment, they know that, but you're going to have to really work very hard. Otherwise, what's going to end up happening, potentially, is your child is going to be adopted out. And that may be with a relative or not. In this court, to be successful, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back here. All right, good luck to you. Thank
Thank you,
you.
Your Honor. May I be excused, Your Honor?
Yes,
Thank you very much.
you're welcome. Who's next? Let me see the NTR. Court is calling 2024 CR 3163 State versus Enrique Soriano. Who's the attorney?